Hello, welcome. Glad to see some people joining us here. I'm watching the number increase on my screen. Well, hello, I'm Lisa from the Law Library, and with me today is Angelica Sciencio, who's our speaker today for Eyes Wide Open on elimination of bias. We're expecting a good number of you today, so I'm going to do a little bit of housekeeping while you get signed in before we turn things over to Angelica today. So, as I'm sure most of you are aware, this is a CLE presentation offering general elimination of bias credit. I wanted to address that this is not a program that will offer implicit bias credit, which is a new specialty credit, but I did have a suggestion for those of you who might still be looking for the implicit bias credit. I did a little bit of Googling today and actually figured out that if you are a state of California bar licensee, there is a free class being offered by the State Bar of California that offers the implicit bias credit. It's one in the e-learning portal that you can get to by logging into your State Bar profile. Again, it's going to be a free class with a participatory certificate offering the implicit bias credits. So State Bar, I think, is trying to help you out with this new category of credit. And again, I just wanted to offer that suggestion for anyone looking for that credit. Of course, you need 2 hours of bias, so this hour will help satisfy that other credit that you need. And I will be sending out the participatory certificates for this program today, a little later today. I just need to download a report from Zoom that tells me who actually appeared, and you'll get that by email. I'm also going to send the handout out again. You know, I tried sending it out ahead of the class. Some of you might have received it, but for some reason, I got a lot of bounce back on that. So I'm going to go ahead and send that out again just to make sure everybody gets it. Another thing I wanted to address today, this is interactive and you will have a chance to ask questions. The way you do that in this Zoom format is using Q&A. You will see the Q&A icon on your screen with 2 speech bubbles. That's a place you can click and post a question that you type in, either with your name or anonymously. It gives you that opportunity if you choose. And I suspect Angelica will be wanting to get through her presentation first and maybe address questions at the end. So be patient while we get through the program and hopefully can get to some of those questions. And then finally, I wanted to address that there will be a survey link you'll see at the end of the program today. We'd much appreciate if you would take our survey. And then one more thing finally, for some of you that have been attending the San Diego Law Library CLE programs, you might have noticed that we have a new registration system. That shouldn't mean much on your end. It helps us out. It's a little easier for us on the back end. And I think it's also going to be making it more likely that everybody gets their Zoom links, and there's no problem with that because you're going to be registering directly in Zoom now instead of in Eventbrite. The only thing that means for those of you who were following us in Eventbrite is that you're no longer going to get any notifications from Eventbrite about classes. So again, if you would like to get those notifications, I would suggest you sign up for our San Diego Law Library e-newsletter that goes out once a week. You can sign up for that on the homepage of our website. All right, I think I've taken enough of Angelica's time. I'm going to get out of the way and turn things over to her.
All right. Hello, everybody. My name is Angelica Sciencio. I am an immigration attorney. I have been practicing for almost 15 years this year. And I'm really interested in diversity and inclusion issues. I have sat on different chair positions with different organizations in the legal field, the California Lawyers Association, Lawyers Club of San Diego County Bar Association, and always focused on areas where I could learn more and be involved in diversity and inclusion issues, especially in the legal profession in California and in the United States. I also have a certificate in diversity and inclusion from eCornell, the continuing education arm of Cornell University, and that definitely gave me insight into different industries and things like that. But it's just a subject that I like, and I hope that this presentation will be helpful. I'm glad to be here. Thank you so much, Lisa, for inviting me to be here again. And let's get started. So the presentation, Eyes Wide Open, How Biases Shape Legal Insight. So what is bias? You know, if you are an attorney, you have to take this similar courses every year. So you probably heard some of these things, but it's okay. It's a good reminder for us to, you know, keep things in mind that will help us in our professional lives and also personal lives, and also help us be a better community member just in general. So here's the Merriam-Webster definition of bias. Um, I can't barely see this. Sorry about that. Here we go. So an inclination of temperament or outlook, especially a personal and sometimes unreasoned judgment, an instance of prejudice and bent tendency. Black's law dictionary definition is very similar: inclination, bent, prepossession, preconceived opinion, predisposition to decide a cause or an issue in a certain way, which does not leave the mind perfectly open to conviction. Other cases, in another case, they define it and explain that this term is not synonymous with prejudice, but explain that a man cannot be prejudiced against another without being biased against him, but he may be biased without being prejudiced. And bias is a particular influential power which sways the judgment, the inclination of the mind towards a particular object. So, why are biases formed? So biases are formed as a result of normal cognitive processes that our brains use to process massive amounts of information. We know that the human brain is an extremely powerful processor, and researchers have determined that the human brain is capable of processing about 11 million pieces of information per second, but only 50 of those pieces of information are processed consciously. So biases are not necessarily tendencies or inclinations that we have consciously, right? They can be unconscious. And of course, if you take an unconscious bias class, you know, even the one that Lisa just recommended from the California Bar, you will go more in depth on the unconscious portion of it. But they can be conscious or unconscious. And how are they formed, right? They can stem from personal experiences, cultural influences, societal norms, and various other factors. So identifying and addressing biases is essential for making fair and informed decisions and for fostering inclusivity and equality. So personal experiences, observations, assumptions, the media, biases or our beliefs, our inclinations can be shaped by history, culture, upbringing, class, race. They can be based on stereotypes, which are fixed and oversimplified views of a type of person or a thing. And it is important to note that we are less likely to stereotype people from our own in-group, right, that are part of our own group. The most important thing that we should take from this is that whether you believe it or not, we are all biased in some way. Now, some of us have inclinations to be biased in certain aspects based on certain characteristics, and others in different ones, but there's always going to be a bias because that is a automatic processing of the brain to help us make quick decisions, and basically in the past and to help us survive and even today, right? Why does it matter? Why do we need to learn this? Because the bar wants us to learn about this. It is a requirement that the bar requires. This is based on the Business and Professions Code of California, but we understand, the bar understands, and science understands that our legal systems can suffer, right, based on biases. So we all need to be aware and receive continuous training to keep that in mind when making our decisions, to make sure that we have a fair and just legal system, which is what we all want, right? And why? Because biases clouds our judgment. It may affect how an attorney views and prepares for a case. give you blind spots as to the type of evidence and whether they're beneficial or prejudicial to one's case. It may lead the judge or, the trier of fact to impose harsher or lighter sentences or damages. It can cause unfair or unequal decisions in hiring, advancement, promotions, mentorship and sponsorship opportunities, business development, compensation, retention of employees. And it can also lead to HR complaints, bar complaints, and lawsuits. We're going to talk about some of the types of cognitive biases. This is an illustration with basically all or 188 different types of biases which have been identified. Some of them are very similar. Some of them are pretty obscure, but they have identified more than 180 types of different biases, and we're only going to talk about 170 of them. No, I'm just kidding. We're just going to talk about some that actually are more common and could have, a direct impact on how we do business as attorneys and how we basically live our lives. I try to outline some scenarios here that will highlight the potential negative consequences of biases for lawyers, emphasizing the need for awareness and avoidance. I think that's what the bar wants for us to do. I also mentioned some situations where biases can be used as tool if ethically employed and can be leveraged in favor of your client, of yourself, of your business, right? But we have to understand that biases give us power and we have to use it for good. But there is the potential that once we understand, we can manipulate them to use it also for unethical ends. So I must stress that while you can use biases or your understanding of biases as tools, their ethical use must be every lawyer's priority, following the rules of professional responsibility and guided by what we hope is a very robust moral compass. It is crucial to employ this understanding responsibly and ethically at all times. So confirmation bias. Confirmation bias is the tendency to search for, interpret, focus on, and remember information in a way that confirms one's preconceptions or existing beliefs. So like they say, once you have a hammer, everything looks like a nail, right? So once you have a belief, we have the tendency to search for and find and give more weight to evidence that already confirms what we believe. And how does that show up in an attorney's everyday life and professional life and personal life? Lawyers might unintentionally focus on gathering evidence that supports their initial assumptions about a case, while overlooking or downplaying contradictory evidence. It can also lead them to interpret ambiguous or complex information in a way that aligns with their preconceived beliefs about a case. Lawyers may tailor their arguments and presentation to reinforce jurors' existing beliefs or biases, attempting to confirm their perspectives rather than challenging them, potentially influencing the verdict. Confirmation bias can also affect how lawyers question witnesses, focusing on eliciting information that confirms their case theory while neglecting contradictory testimony or perspectives. And of course, when you hear that, it's like, yeah, that's what I'm supposed to do as an attorney, right? That's what I want to do. In this case, obviously, you want to be more aware of what the other person is doing so you can be prepared to challenge the line of questioning or explain it to your jurors, but just basically understanding this and being aware that this could be happening is very helpful. Confirmation bias can also affect the direction of legal research, leading lawyers to prioritize sources or studies that confirm their assumptions while overlooking alternative viewpoints or perspectives. So what is the impact? Confirmation bias can impact case evaluation, strategy formulation, presentation of arguments, and decision-making, potentially influencing outcomes and the overall effectiveness of the legal presentation. So here's some examples, some studies or experiments that they did. the forensic experts experiment where researchers took fingerprints that have been previously examined by experts to make positive identification of suspects. Then they presented the same set of fingerprints again to the same experts, but gave a context that suggested that they were a no match. And so the suspects couldn't be identified. With this new context, most of the fingerprint experts made different judgments, contradicting their own previous identification decisions. So simply by giving some context, giving some additional information that is really not a part of the objective evidence, it can change, and it did in fact change the identification or the decision of these experts, right? People who really know how to do this. There was another study with forensic experts where they gave forensic examiners a full human female skeleton for analysis and gave context that assumed it was of a female. 100% of the examiners determined it belonged to a female human. But when before analysis, the contextual information indicated that the skeleton was male, only 38% of the final determinations were correct. So it's not because you get an expert opinion that you are getting an unbiased opinion, right? So we just have to understand that context matter. So even if you have an expert opinion, it might be worth it to question or get a second opinion, etc. Another experiment, this one you probably have heard, this is related to the legal profession as well. It's very interesting. It's the third year associate experiment. Here, partners at law firms were given context information about Thomas Meyer, who was a third year associate and NYU grad. And half of the partners were told that Meyer was white, and half were told that Meyer was African American. So, can you just, read this memo here from that, African American lawyer, the new, third year associate that we have here, and ask the partners to evaluate the memo for written and legal issues. So all partners were provided the same exact memo, and the memo did contain some spelling mistakes, factual errors, and technical errors. So here are the results of that experiment. Thomas Meyer, African American, and Thomas Meyer, Caucasian, right? Remember, all memos were exactly the same with the same mistakes. But when reviewing the African American Thomas Meyer's memo, partners found about 5.8 out of 7 spelling errors, 4.9 technical errors out of 6, and 3.9 out of 5 factual errors. The overall score of Thomas Meyer, the African American Thomas Meyer, was 3.2 out of 5. Okay, that's what they scored the memo that Thomas Meyer, African American, had written. But when reviewing the Caucasian Thomas Meyer's memo, they only found 2.9 out of 7 spelling errors, 4.1 technical errors out of 6, and 3.2 factual errors out of 5, giving Caucasian Thomas Meyer a 4.1 out of 5 score. So almost a whole point there more. And what does that show us? Or the conclusion was that there may be a belief, and it indicates that there is definitely a bias in believing that African Americans, are more prone to making spelling errors, technical errors, and factual errors. And you can see how problematic that is, right? How that could affect somebody's career, that the same work, the exact same work, people go in because of their beliefs that there could be errors, they go in looking for the errors, right? And in this case, potentially prejudicing the African American associate at this firm. Availability bias. So availability bias is a mental shortcut where individuals rely on readily available information when making decisions. So we often use data in our minds, right? When making decisions, we will use data from information that comes from memories that are recalled more easily than others, from memories that are recalled more often than others, and from more recent memories. But basically, our decisions are made based on the information that is already kind of in our head, right? And because we have the tendency to remember things that we talk about more often or that is more recent, we may be avoiding some other evidence that is contradictory and that could help us make a better, more informed decision. What is the effect of the availability bias in our lives? So lawyers might be inclined to focus more on recent cases they have encountered or those that are widely publicized, leading them to overestimate the relevance or importance of these cases compared to older or less memorable precedents. Lawyers might heavily rely on precedents that readily come to mind due to their frequency in legal discussions or media coverage, potentially overlooking less common but crucial legal precedents that could be pertinent to the case at hand. Of course, as attorneys, before we'll file something, we'll do a full research of the issue. But let's just say that you are thinking about taking a potential client or you get a call, you may have things in your head that are that are coming up and makes you make a decision, oh, maybe I don't want this case, but that could be case on point or other resources that could be very beneficial, and maybe you're giving up a case that could be very, where you could really help that client. Oops. So lawyers might overlook or undervalue alternative, less conventional approaches that could offer a viable solution or advantage in specific cases. And in this case, you can, use it proactively and repeatedly emphasize strong arguments or facts during a trial or negotiation. By continuously bringing up specific points, you increase the availability of those arguments in decision makers' mind, potentially influencing their decisions. And I know we already kind of do that, right? But why? Now we know why, that this is really something that we as humans have the tendency to do. Some of us, right? The impact here, it can impact a lawyer's professional life, can influence case strategy, risk assessment, client counseling, and decision-making by favoring more accessible or memorable information over having a more comprehensive analysis of all relevant factors. So this is another experiment that they did, instructions to forget. So individuals were provided with context about a worker's behavior, and the behavior was positive or negative. Then they had the subjects, and they were given a sheet, a checklist to evaluate the behavior of that worker. And they gave this context, right? Like, oh, you're going to evaluate this person, but don't worry, they're really nice. Everybody loves them here, right? Or they said, oh, you're going to evaluate this person. They are in trouble. They're just like cause a lot of trouble. So they gave information that was positive or negative about that person. And then they instructed the subject who was doing the evaluation to forget the information, either by saying, oh, that person that I told you that about, I was actually confusing them with somebody else, and that wasn't the right person, so forget what I said about them. Or they would say, hey, you know what I told you about that person? I wasn't really supposed to tell you that, so forget what I said. The results, despite the forget instruction, subject judgments were affected by the to be forgotten information. Also, the reason for the instruction to forget affected their judgment. So the ones that you said, oh, I wasn't supposed to tell you that, is the information that stuck. So if you say, oh, I wasn't supposed to tell you that, forget what I said, that really stays. So it has basically the opposite effect. Whereas if you said, oh, you know, I was confusing the person, or you really, that information wasn't correct, is less likely to stick. So we are really every day being influenced by outside forces. I just watched a show on Peacocks called Mrs. Davis, pretty interesting. And no spoilers here, but the main character comes from a family of magicians, and the mother says, you know, be careful with the force, right? Be careful with the outside influence that comes in your mind, and it definitely affects probably all of us. So we just have to be aware to avoid this thing. So you know, it's relevant in many areas, but especially when improper evidence is blurted out in a court and the judge says to the jurors, forget this, you're not supposed to consider this evidence. Well, guess what, right? It will certainly or most likely impact the juror's decision. So anchoring bias happens when, you know, we have a tendency to rely heavily on the first piece of information encountered when making decisions. How does that show up? For us, lawyers might be influenced by the initial settlement offer presented, whether it's made by their client or opposing party. The initial figure can set an anchoring point that can be challenging to move away from during negotiations, potentially impacting the final settlement. Lawyers' early discussions with clients might inadvertently set anchoring points regarding the expected outcomes of the cases. If initial expectations are unrealistic, it can be challenging to manage the client's perceptions or their satisfaction as the case progresses. And lawyers can also use anchoring to their advantage during negotiations by setting the initial terms of proposals, aiming to create an anchoring effect that favors their client position and negotiation outcomes. So we kind of know that already, right? But like, this is a real thing, a psychological thing, and understanding why we do that, I think, is important. So the impact here allows lawyers to navigate its effect, you know, and understanding the potential impacts of the anchoring bias allows lawyers to navigate its effects strategically, allow them to mitigate negative impacts while leveraging it to their advantage in presenting arguments, negotiations, and managing client expectations. So here's an experiment on anchoring bias. This was the auto accident damages experiment. They gave 65 New York trial judges a filing, right, and asked them to review that petition and award pain and suffering damages to an automobile accident plaintiff. Half of the judges were told that pain and suffering damages cap was $750,000, and half of the judges were told nothing. And here are the results, right? So judges that were provided with the cap information awarded an average of $250,000 in damages, whereas judges that were not provided with the cap information awarded an average of $100,000 in damage. So a substantial difference there, $150,000 difference that you could, you know, be leaving on the table if you don't use, or as long as ethically using an anchoring point when participating in negotiations for your client. So very relevant. Here's framing effect. So framing effect is the tendency to draw different conclusions from the same information, depending on how that information is presented. I apologize for this. I'm not a great illustrator. I did this and I actually put the wrong number here. This is supposed to be 20%, but the illustration here means if you go to the grocery store and you look at beef, right? Are you gonna buy the one that says 80% lean beef or the one that says 20% fat? So this should say 20% here, guys, sorry. But you know, this is the type of things that you do when you're framing. You get the same information and then you just basically manipulate the information to show it in the best possible light for the outcome that you're looking to obtain. So framing effect, how does that show up for us? So lawyers can strategically frame legal arguments or present evidence in a way that influences how judges and juries perceive the case. Presenting facts in a certain order or emphasizing particular aspects can impact the perception of the case's strength. Lawyers might employ the framing effect when proposing settlements, presenting offers in a manner that emphasizes certain benefits or consequences to influence the opposing party's perception of the proposal's fairness or advantage. And you might frame the risks associated with different legal strategies in a way that are more in line with your client's risk tolerance or perception of potential outcomes, impacting their decisions on how aggressively to pursue or settle a case. By understanding how framing influences perceptions, lawyers can strategically frame arguments, evidence, and legal precedents in ways that favor their case. This involves skillfully presenting information and structuring arguments to influence decision makers' perceptions and interpretations in a manner that benefits their client's position. Risk aversion. We're going to talk about default effect. Risk aversion is a form of default effect, but I kind of wanted to touch upon the impact of being risk averse in our field. So risk aversion is a tendency to avoid risk and having a low risk tolerance. I am one of those people, especially when, working in immigration. You want to really make sure that you're not going to file a petition that has kind of chances to be approved, but if denied, it can really cause serious consequences for your clients. And, sometimes you will avoid taking the case, but then you really miss the opportunity to help somebody, right, with your knowledge. So here's how it shows up. Prosecutors, right? They might hesitate to prosecute cases where the evidence is strong, but pursuing them would require extensive effort or could lead to potential criticism or controversy. That would not be good, right? Lawyers who are risk averse may be advising clients to settle rather than pursuing complex or contentious legal battles, even if the case has strong merits. This avoidance of potential conflicts might stem from a fear of failure or the effort required. Risk aversion can also lead lawyers to stick to traditional legal strategies or precedents rather than exploring innovative or less conventional approaches that could be advantageous for their clients. Lawyers may opt for more stable or conservative career paths within the legal profession, avoiding entrepreneurial ventures, leadership positions, or practice areas that are less established or perceived as risky. And lawyers might also avoid investing time and effort into acquiring new skills, such as technology or marketing, which are necessary for adapting to the evolving legal landscape due to a preference for maintaining the status quo. So can result in missed opportunities for professional growth, innovation in legal strategies, and taking calculated risks that could lead to greater success or fulfillment in their careers. The default effect is similar. It's the bias where people tend to favor the status quo or default option or a default option. It comes up, it shows up, lawyers might default to using conventional or previously employed legal strategies, even if alternative approaches could be more effective in certain cases. This bias might limit innovation or creativity, You may default on relying heavily on established legal precedents without exploring new or evolving interpretations, potentially limiting your ability to adapt to changing landscapes. Lawyers might default to advising clients to accept standard or default settlement offers without exploring alternative negotiation when this bias is at work. And lawyers also might default to standard processes or case handling methods without critically evaluating whether these methods are the most efficient or suitable for each case's unique circumstances. Could also lead an attorney to have reluctancy to adopt new technology that could streamline processes and enhance efficiency. Impact. Understanding this and recognizing this is crucial for us so we can make informed, deliberate decisions in the legal practice. By consciously evaluating options beyond the default or status quo, lawyers can potentially identify more effective strategies, better serve their clients' interests, and adapt to evolving legal environments. I remember reading about, I don't have the citation for that information where it came from, but there was a county that was accepting driver license and IDs applications online, and their organ donor opt-in was very low until they basically pre-checked the yes box. And of course, the person could still go there and remove it from yes and put it to no. And of course, they saw a huge increase in people signing up to become organ donors. So that is the default option, right? Bias, where it's already there, leave it. You don't have to make that decision. Basically, the decision is already made for you. The ostrich effect bias is the tendency to avoid or ignore negative information or situations, probably one that will cause us the most problems if we really are not aware of this tendency, if we have them. It will show up in case assessment and strategy, where lawyers might avoid acknowledging or addressing potential weaknesses in a case, leading to an incomplete or biased assessment of the case's strengths and weaknesses, or even overlook or downplay adverse evidence or legal precedents that could weaken their case, potentially resulting in ineffective strategies or inadequate preparation. Lawyers might hesitate to have challenging discussions with clients about the potential risks or unfavorable outcomes of the case, potentially leading to unrealistic client expectations. And this effect, the ostrich effect bias, can also result in delaying or avoiding updating clients about negative developments in their cases, which could impact trust and transparency in the lawyer-client relationship, and potentially even cause a bar complaint there for inadequate communication between attorney and client. Lawyers might resist or avoid adapting to new legal trends, technologies, or methodologies, potentially hindering their professional growth and effectiveness. And the ostrich effect bias might also cause lawyers to disregard or overlook constructive feedback or criticism about their performance, inhibiting opportunities for improvement. The impact then can lead to avoidance of critical information, reluctance to confront challenges, and delayed or inadequate responses to important issues, potentially impacting case strategies, client relationships, and professional growth. Negativity bias. Anybody? The negativity bias occurs where negative experiences or information have a stronger impact on individuals rather than positive ones. So they have stronger impact than positive ones. How does it show up, right? So lawyers might be more attuned to potential risks or negative outcomes in cases, leading to a cautious approach. This bias can influence decision-making, sometimes leading to a tendency to focus more on potential negatives than positives. Lawyers might emphasize potential risks or negative aspects of a case to ensure clients are fully informed. However, this could potentially create heightened client anxiety or a more pessimistic view of the case's potential outcomes. Lawyers might allocate more resources towards mitigating potential risks or negative outcomes, impacting the balance of resources and efforts in legal strategies. Constant exposure to negative legal situations or high-stake cases might contribute to higher stress levels or burnout among lawyers due to the prolonged focus on negative aspects of legal matters. And the negativity bias might also lead lawyers to perceive the legal environment as inherently challenged or adversarial, potentially influencing their attitudes towards their work or the profession in general. And we know that, you know, our profession is not challenging or adversarial. Yeah, of course it is. But if you have this predisposition to think that everyone is adversarial, you might miss the opportunity to work with opposing counsel that is, you know, very fair and really wants to negotiate for what's best for the parties. But because you think everybody, you know, is adversarial, you might not have this opening in certain situations. I have to confess that this negativity bias is one of the things that that I learned about myself once I had a consultation, and after the consultation, the prospective client said, "Wow, that was like felt like a bucket of cold water, right? That somebody threw on me," and I definitely didn't want to have that. I didn't want my client to have that perception, right? But I am a person who likes to, when I am consulting somebody, I want to know everything and the worst case scenario so I can make an informed decision. But because I want to make sure that the person really understood, maybe I just went overboard with the negative sides, right? Instead of focusing on the positive and really giving client hope. If it can be done, it can't be done. But you have to balance that, giving all the information, but also not, you know, just hammering on the negative information. So it actually, when I heard that, I didn't know how to process, went home, thought about it, I was like, okay, I know this is happening. It's still hard for me because I really want to make sure that people know, but I have to also be mindful and make sure that I'm not overemphasizing points that are negative, especially when there is the potential for a client to actually get the outcome that they are looking for. So the impact here, recognizing the impact of negativity bias is important to maintain a balanced perspective, manage stress, and ensure that they approach legal matters with objectivity and a comprehensive view of both potential risks and positive aspects of cases. Balancing a realistic assessment of risks with an optimistic outlook on case strategies can help mitigate the impact of the negativity bias in legal practice. Overconfidence bias. Never seen it. Do you know a lawyer who's overly confident? Of course, right? Many, many of our colleagues. And if we have an overconfidence bias, you have the tendency to overestimate your knowledge and abilities in a certain area. Here's how it shows up, right? So lawyers might exhibit overconfidence in their case assessment or legal strategies, leading them to believe that their arguments or positions are stronger than they actually are. This bias might lead to overlooking weaknesses or risks in their case. Lawyers might be overly confident in negotiations, leading them to overestimate their bargaining power or the strength of their case. This could result in missed opportunities for more favorable settlements. You may provide exaggerated assurances to your clients. You may convey excessive confidence to your clients about case outcomes or legal strategies, potentially raising unrealistic expectations. This bias may affect clients' decisions and satisfaction with the legal representation. And lawyers might underestimate the risks associated with certain legal actions and decisions, leading to potentially detrimental outcomes due to an overly optimistic assessment of the situation. So How does it impact? Recognizing and mitigating overconfidence bias is essential for lawyers to make well-informed decisions, manage client expectations realistically, and ensure effective legal representation without overestimating their abilities or case strengths. Striving for a balance and critical assessment of situations can help you navigate the complexities of legal practice more effectively. Bias blind spot. This is a tendency to see oneself as less biased than other people, or to be able to identify biases on other people more than identifying them in yourself. How does that show up? Overconfidence, right? Again, you might believe that they're immune to biases when evaluating cases or developing strategies or living life, leading them to overlook their own biases in interpreting evidence or assessing the strengths and weaknesses of a case. You might assume that you're providing completely impartial advice to your clients, disregarding the possibility that their own biases could influence the guidance given or the options presented to your clients. And it can also lead you to underestimate the impact of your bias on understanding and empathizing with your client's perspectives, potentially affecting client trust and the effectiveness of the representation. Okay, so this is how the impact, right, can lead to overconfidence and objectivity, misunderstanding client interactions, and flawed decision-making processes, potentially impacting legal strategies, client relationships, and negotiation outcomes. The G.I. Joe fallacy is the mistaken belief that mere awareness of a cognitive bias is enough to overcome it. So knowing is not necessarily half of the battle. Knowing about a bias is not going to make sure that you overcome it. So you really need to be intentional about evaluating your beliefs. Other types of cognitive biases, humor effect, right? Information presented with humor is more easily remembered and positively evaluated compared to information presented without humor. So using humor strategically in courtroom presentations, client interactions, or negotiations can potentially enhance the memorability of key points, establish rapport, and positively influence the audience's perception of your argument or demeanor. However, it's important to note that the effectiveness of humor in a professional setting is highly dependent on appropriateness, timing, and audience reception. Inappropriate or poorly timed humor can backfire, negatively impact a lawyer's credibility, professionalism, or the receptivity of their arguments. It can also affect your career as a comedian when you host the Golden Globes. If your lawyers are not very funny and rude, basically. Picture superiority bias. Information presented in visual or image-based formats is more easily remembered, and understood than textual information. So you may want to use visual aids, diagrams, photographs, multimedia presentations to enhance the presentation of evidence in court. This can make complex information more understandable and memorable for judges and juries. You might use visually appealing materials also in marketing efforts, such as websites or brochures, business cards, to capture the attention of potential clients and convey information more effectively. Obviously, I'm not very aware of this bias because my presentation is pretty plain and my graphics are, done with all the skills that I have to put them together. So sorry about that. Serial position effect. So where people tend to remember, or they say that some people tend to remember the first and last items in a series better than those in the middle. So you may want to structure your legal arguments, your motions and writing this way to maximize retention of information. And this is not something that I usually do. If I'm making a legal argument, it goes strongest, second strongest, third strongest. Maybe you want to save one of those strong ones for the end if you need the person who's reading to remember that information more easily. And then the halo effect, where a person's qualities or characteristics influence perceptions about their other attributes or abilities, positively or negatively. So people tend to be influenced by their previous judgments of performance or personality. So if a lawyer has charisma, confidence, and even if they're physically attractive, they may be perceived as more skilled or professional. And of course, you could be wrong. Studies indicate that when you first meet somebody and you find them attractive, that you are more likely to make probably erroneous determination that they're also smart or skilled in some areas. So do with that what you like. Obviously, we're dumb animals, right? We really make those connections, but let's just be aware that one thing may not have anything to do with the other. I try to, get this presentation to be a little bit more light and more practical on things that really can affect you on your day-to-day. I, of course, would like also to mention, our big ones, our insidious tendencies, right? And also sometimes intentional, conscious beliefs about other people. And we have to mention racism. It exists. Sexism. It exists. Discrimination against gender identity, trans sexuality, and things like that. It exists. Sexual preference discrimination, classism, socioeconomic discrimination, ageism, ableism, and also prejudice and discrimination about many more things: hair texture, height, language, accents, looks, mental disorder, ethnicity, skin color, viewpoint, religion, political view, culture, and many others. This presentation is not focused on those things. I hope that with everything that we have been living since 2020, with social unrest and everything that is going on in the world, we're really all educating ourselves individually through, these presentations, and also by our own desire to learn more about these things that affect people's lives so negatively. I'm going to bring up a study from the ABA from 2018. I thought that by now we would have a new one. I couldn't find anything. So this is the latest research that they did, or survey that they did, with 2,827 lawyers who were surveyed, talking about the things that they face in the workplace. And the types of things that they face in the workplace are these. Let's open up a little bit. So they were asked questions such as, do you feel like you have to prove yourself over and over and over in the workplace to be recognized? And here you have 4 columns: white men, white women, men of color, and women of color. And I kind of highlighted the higher, or the more negative views on these questions. And as you can see, women, they really feel they experience certain microaggressions at work, and it's, this is a reality. A lot of us experience those things. So questions like, do you feel like your work has to have higher standards than other people? So women of color, 67% of women of color saying yes, only 34% of white men saying that. Do you feel like your ideas are valued in the workplace? Only 78% of women of color said yes, while 91% of white males said yes. Do you feel like people take your ideas and pass it as their own? Again, white women, 78%, white men, 28%. Do you feel like you're rarely interrupted at work? So you can read the numbers and the materials, but these are the things that happen every day in our workplace as attorneys, right? Do you feel like it's okay for you to be assertive? Do you feel that it's okay for you to self-promote? Are you free to express anger in the workplace? Are you often given more administrative tasks instead of high quality assignments, right? Do you feel like the parental leave, taking parental leave would be harmful to your career? And again, women saying yes, more women saying yes than men. But, when we look at parental leave harming career, for example, here, 57% of white women said yes, they have that perception, but also 42% of white men. So this is a thing that affects, both men and women, not equally, right? Still affects women more negatively, but these things also affect men and men of color and white men. Single people, non-parents, do they feel like they have to spend more time at work because they don't have children, right? Are you happy with the amount of female support you get? Do you feel like you're given good mentors? So take a look at this. This is very telling. And, it's pretty clear that gender and race bias exists. It's alive and well in our profession. And that's why we have to be very mindful of what is going on and how they affect other people. So what I can do to minimize the impact of bias? I'm going to skip here once. I have a little video that I want you to watch. But one of the things in this study was the mistaken identity problem that women have, which is they're often thought, you get to a mediation and they say, oh, are you the court reporter? No, I'm the attorney, right? And women suffer that all the time, and women of color a lot more than the other groups here. 57% of women say that has happened to them, where only 7% of white males said that has ever happened to them, that their identity, they're always assumed to be the attorney, and women are like, oh, are you the paralegal? So I want to show you a TikTok that I was actually watching yesterday, and this is exactly on point. So I'm going to play that for you. I hope you can hear it.
I'm a lawyer, and today while I was at work, I walked into a criminal courtroom, and the judge, who is an old white man, took one look at me and then said to my colleague, oh, there's your client. And the bailiff had to correct him. I can't say that I am surprised, but I am disappointed. I think deep down I expected it to happen at some point in my career, but I still was not prepared for it.
All right, guys, let's be careful with the assumptions we make. This is very heartbreaking. I cried a little bit, and this is really something that we don't want happening to anybody, any of our colleagues, right? Especially our colleagues who are women and women of color and people of color. We really just want to make sure that we are not making assumptions and asking people and always assuming the best, right? So what can we do to minimize the impact of bias? Self-reflection, right? Take time to reflect on your own biases and assumptions. Acknowledging them is the very first step to reducing their influence. Education. Learn about different cultures, perspectives, experiences. Read diverse authors. Engage with content from different backgrounds. Seek out information that challenges your existing beliefs. Commit to ongoing learning and growth. Attend workshops, seminars, or training sessions on diversity, equity, and inclusion. But don't be limited to the 2 credits that you have to provide the bar. Listen actively, question your assumptions, diversify your circles, right? Engage with people from diverse backgrounds. Support equity initiatives, be on the right side of things, right? As things affect people's lives, we really should be mindful. Confront bias, encourage feedback, and remember these steps are part of an ongoing journey. Consistent effort and a willingness to learn and grow are crucial in minimizing. I'm going to open for questions here really quick, but there is one thing that I wanted to tell you is that I have personally recently embarked in an arduous journey of personal spiritual development, and understand now that we are really, all of us humans are in fact beautiful flowers in God's garden, or the universe's garden, whatever you want to call. And we are worth exactly the same as one another. And I now can see that the root of every problem and evil in the world today can be attributed to someone, somewhere, individually or as part of a group, thinking and acting based on the misconception that they are somehow better than another person. So as long as we think like that, I think that there will never be equity and peace. So self-reflection, self-awareness is key for us to break harmful cycles. So, all right, Lisa.
Okay, we're getting close to being out of time, but real quickly, maybe we can get to a couple of these questions and comments. We have one from Joni. It's a little long, but I'll try to read it quickly. We've seen in recent nationwide incidents a question of whether bias can come from those who provide gifts, economic opportunities, trips, etc. For instance, for judges, why aren't these influences listed among sources of bias? Can't they cause a lawyer or other justice professional to lean more heavily toward the bias of the influencer? So I think that's sort of the conflict of interest type of bias.
Yeah. Yes, absolutely. I think so. But I wouldn't say that kickbacks are biases, right? They're just like they're direct influences. Biases are more of the cognitive processes that happen in our lives. But I think that absolutely, yes, of course.
And then a comment from David about the third-year associate study. He felt maybe it was not large enough to be valid. And did you have a comment on that?
No, I really don't. I think that it was quite a large number. I mean, if you're thinking 7, 8, 5, those are the number of mistakes that were on the memo. I don't really have the numbers, but I think it was kind of a large sampling of partners that were actually provided. I don't have the numbers. I'm sorry, I don't recall, but I can send that to you, David.
And he also had a question about the auto accident scenario. I think this is where the judges were awarding the pain and suffering damages. Were the only choices that they were given either 100,000 or 250,000?
They weren't giving any choices. The only thing that they were said is like award whatever you want, but there is a cap at $750,000. So that was the average of what came out.
Question from Suzanne. Are you aware of any research on attorneys with disabilities and attitudes toward attorneys with disabilities?
I know that the San Diego Bar Association has a different abilities resource group, and they do a lot of work on that. I really wouldn't have any research, but they would. And if you want to contact me, David, I can, or sorry, the other person I missed, I don't have the name of the person in front of me. But if you want to contact me, I can put you in touch with that section of the San Diego County Bar Association. And if you're interested, maybe you want to join the bar and that group to be more informed and advocate for lawyers with different abilities.
All right. Well, with that, we are out of time. It flew by. Thank you so much for the presentation, Angelica.
So much.
Thank you, everybody, for attending today.
Okay. Have a good day.